This 5-year guideline impacts how families manage their housing, yet many retirees do not learn about it until they are no longer able to adjust their plans. If you are 65 or older, if you own your home, or if you hold any savings, you should learn precisely how this system operates, since understanding it early provides a very strong advantage for your future. There is one legal document that can help manage this process before care is required, and some estate planners might not discuss this approach unless you request it specifically by name. I will share exactly what this document is called before our video is over. The policy itself is known as the Medicaid lookback period, but this term requires context. It is not merely a brief review. It involves evaluating past financial actions you took when you perhaps had no idea they impacted future care. Here is how it works. If you ever require long-term nursing facility care, and considering average care in this country now costs over $18,000 per year, you may unfortunately run out of personal funds. Therefore, you might need to apply for Medicaid to help cover expenses. However, before Medicaid approves any financial coverage, a state caseworker will review every bank statement, every property record, and every gift you have made for the previous 60 months, assessing single transfers, any check to a grandchild, any car you signed over, and dollars you moved. Then they calculate eligibility penalties. This penalty is not a fine. It delays your benefits. The state takes the total amount you transferred during those 60 months, divides it by what they call the regional penalty divisor, which in most states sits between $10,000 and $12,000. And the result is the number of months you remain ineligible for Medicaid coverage. During those months, you must pay for the nursing home yourself at over $9,000 per month, even though the primary reason you applied for Medicaid is that you cannot afford $9,000 per month. This is the challenge. You gave away that money, therefore, you cannot pay. But because you gave away that money, the state program will not pay either. So who pays the care facility? The care facility requires prompt payment. They collect debts, and a primary asset they might look toward is your house. Many individuals assume this rule only flags large transfers. That is incorrect. The review process notes everything. A $400 holiday check to your granddaughter counts. Paying for your child's wedding counts. Helping a grandchild with college tuition counts. Forgiving a loan to a family member counts. Selling your vehicle to your nephew for $1 counts. Even charitable donations over a certain threshold might count depending on your state. There is no birthday exemption. There is no holiday exemption. There is no simple unawareness or ignorance exemption. The federal annual gift tax exclusion, which is currently set at $19,000 per recipient, generally has nothing to do with this. That is an IRS regulation. Medicaid remains a completely separate system with its own guidelines, and Medicaid uses different criteria than the IRS uses. A transfer that is perfectly legal under federal tax law might still trigger a strict Medicaid penalty. Many individuals do not understand this distinction. Therefore, they assume their previous gifts comply. They might not. Now here is where it becomes complex, and this is the detail that complicates financial security for surviving spouses. If you are married and your partner goes into a care facility, you might assume the law fully protects the healthy spouse who stays home. There is a protection. It is called the Community Spouse Resource Allowance. And in 2026, it allows keeping $157,920. That is the maximum amount of countable assets the at-home spouse is allowed to retain. Everything above that number must be spent down before Medicaid will pay any coverage. $157,000 sounds like a lot until you realize what it actually has to finance. Property taxes, home repairs, Medicare premiums, food, gas, medications, and emergencies for the rest of the healthy spouse's life, which could span decades, translating to a very strict monthly budget. That is the financial reality you must navigate while your husband or wife is in a facility that requires over $9,000 per month for that very same extended time period. But regarding the house, surely the house remains. The house is often thought to be fully protected. That is what almost every retiree in America assumes, but it is incorrect. The house is protected while you are alive and residing there. Therefore, Medicaid will not require you to sell it before gaining eligibility. But the moment the Medicaid recipient passes away, a legal process called the Medicaid estate recovery begins. Federal law requires every state to attempt to recover the cost of care from the estate of any Medicaid beneficiary who was over 55 at the time benefits were distributed. The primary recovery asset is property. The state initiates a claim against the estate. Surviving heirs are informed they must either settle the bill in full, sometimes totaling hundreds of thousands of dollars, or sell the property to satisfy the claim. The average estate recovery claim in this nation currently exceeds $74,000, and in certain states it reaches over $200,000, and compliance is legally required. It is generally non-negotiable. The federal government mandates the state to seek repayment through property. Therefore, the residence your parents intended would pass to the grandchildren might end up sold to reimburse the state where they happen to reside. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an existing legal framework on the books called filial responsibility. These statutes dictate that adult children might be held financially liable for the outstanding nursing facility bills of their parents. For years, these statutes remained inactive. But starting in 2012, after a Pennsylvania appeals court ruled that a care facility could collect $93,000 from an adult son for his mother's care, legal precedents shifted. Therefore, the concern is not merely that the state claims your property. The real risk involves the care facility, after the state completes its recovery, potentially taking legal action against your children for whatever debt remains unpaid.